Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, trying to bring information to all those who are struggling with serious debt problems, whether we're dealing with bankruptcy, garnishment, debt collection lawsuits, whatever your debt struggle or topic is today. We do this live stream each and every week on Thursday nights to go over, just discuss these topics, discuss maybe problems you're having or struggles or resources you're looking for. That's what I'm here to do. I am an attorney in the state of Arizona. I help people with bankruptcy, defending debt collection lawsuits, consumer type debt related issues. And so this is what we do, is to bring information to help you to make those decisions, to really try to get out of that dark space that sometimes you can get into when you're dealing with serious debt issues. So each week, I provide my weekly disclaimer that while I am an attorney in the state of Arizona, I'm not licensed anywhere else, so you should take this for what it is, some guy talking on YouTube, and that's about it. I will provide you some resources to be able to help out, as far as if you're representing yourself, if you're looking for an attorney in your particular state, if you need legal advice, that's what you should do, is you should talk to an attorney in your particular state. If you're in the state of Arizona, I do consultations. I do not charge for them. I'm happy to see how I can help you out. I'll put it in the chat section here. If you are in Arizona, a link where you can set up appointments. And like I said, you'll talk to me directly on this. I'll go ahead and shoot that there. So something I wanted to share with you before we get started today. Today's a pretty big day in the Consumer Warrior YouTube channel. Today, we hit 4 million views, which is pretty cool. 4 million, that's a lot. It's a lot to me. I started this channel years ago, just trying to provide information to help people out with these very difficult situations. And it's kind of cool, the reach of YouTube, the reach of the internet. I get people all the time who, when they call into me, that's how they said how they found me, is through YouTube. But that these videos have been watched 4 million times is pretty crazy to me. So, all right, so let's jump in some of the questions. Now, like I do each and every week, I like to pull some questions from the comments section that have some general applicability. This one here, I think, is very helpful, particularly if you're dealing with a debt collection lawsuit. Said, I just received a lawsuit complaint. Do I send an answer first and then file for a stipulated judgment, or is a stipulated judgment supposed to be my initial response? The reason why I thought we could bring this one up, a stipulated judgment is a very powerful tool to resolving a debt collection lawsuit, particularly if you don't have a lot of money to come in and offer any type of settlement. Now, I always say I break my debt collection lawsuits into two groups. There's original creditor lawsuits, American Express, Discover, those types of credit cards. And then there are junk debt buyers, companies that went out and paid pennies on the dollar for these lawsuits, or for these claims, to be able to pursue them through a lawsuit. We're talking portfolio recovery, LBNB, Resurgent, Midland Funding, all those cast of characters. If you are trying to settle, particularly if you're dealing with an original creditor lawsuit, I always say it's a good idea to look at settlement rather than pushing something like that to trial, because unless you have like an identity theft type of defense, they're likely going to win that lawsuit. But, in most cases, when people think of settlement, they think of lump sum. If they think, hey, I'm being sued for $10,000, you call the creditor and they'll say, hey, I'll take $9,500 or something stupid like that. It is possible to settle on a payment plan, but once a lawsuit's filed, you are likely going to have to do that with a stipulated judgment. Let me tell you what a stipulated judgment is. The whole end goal of the creditor is to get a judgment against you, because once they're armed with the judgment, they can garnish wages, bank accounts, all that kind of stuff. What you can offer them is a reduced amount. So let's say they sued you for $10,000. You could go to them and say, look, I'll settle with you. I'll pay you $4,000. I can only pay you $250 a month. But I will offer you a stipulated judgment for the full $10,000 that you're seeking. But as long as I'm making my payments on time, the $250 a month, there's no further interest. You have to agree not to do any type of collections. And once that $4,000 is paid off, we're done. But if I miss my payments, if I just blow it off and I don't make a payment, or something happens and I can't make the monthly $250 payment, all bets are off. You have your judgment for the full balance. The reason why that's attractive to the creditor is, one, they have a judgment Two, if you fall through in your payment plan, they don't have to go back and try to resue you or worry about statute of limitations issues that may be coming up. So that may be a tool you can use and offer if you're trying to do something on a payment plan, particularly if it's going to be like a low dollar payment plan. You can reach out and offer that as a way of trying to resolve it without having to come up with a bunch of, big lump sum as far as they go. So, all right, let's jump into a couple questions here. Carla says, being sued by Synchrony Bank, not sure if I should try settlement or arbitration or trial, and what order to submit a request for the different options that I have. I'm in Tennessee. Okay, so if it's Synchrony Bank, and Carla, you can maybe put something in the chat here. Is it actually Synchrony Bank who is filing the lawsuit? And I'm not talking about their attorney, but is it the actual creditor, Synchrony Bank listed as the plaintiff, or are they a junk debt buyer? And the reason why I ask is Synchrony sells a lot of their debt. So a lot of times, and the way you approach it when you're dealing with the debt buyer as opposed to original creditor can be treated quite a bit differently. But let's see. So, your options are settlement, arbitration, or trial. And it's kind of similar to the approach I tell people that come into my office. If you've been sued by someone, you really have three options: fight it, settle it, or file bankruptcy on it. So your first option is settlement. I always think settlement is a decent option. I know, I was talking to someone today here at my practice in Arizona, and they were like, I'm not going to settle with these people. I'm just going to fight them kind of thing. I get it. And in certain situations, it makes sense to fight it. But in a lot of cases, I can tell you the court process is really, there's a lot of uncertainty in it. And I know that sounds weird, and people struggle to hear that from lawyers. They're like, gosh, you're working this all day. You went to all that school. You should be able to tell me this is what's going to happen. There's a lot of variables in each case. And in each court, there's a lot of variables. If you go before a jury, if you go before a judge. And so there's, any attorney that tells you slam dunk, we're going to win this case, they don't know what they're talking about. You should go find someone else, because every case, no matter how airtight it is, there's a chance that it could end up different. I always go back to, if you're older like me, O.J. Simpson case. Most people did not think that thing was going to play out the way it did, as far as just the legal proceedings. Anything's possible. And not that your debt collection case is O.J. Simpson case, but I'm just saying that some of the same factors come into play there, whether it's the judge, the plaintiff's attorney, all that kind of stuff. And so settlement, if you can get something, if someone's suing you for 10 grand and you can get that thing settled for $3,500, the way to think about it is, I just saved myself $6,500. Not that I had to settle and pay them $3,500. You saved a ton of money in entering into type of settlement. So settlement's always an option. Where I recommend, if you're trying to reach out and settle with Synchrony Bank and they're not willing to settle with you, that's when I say, particularly if there's a lawsuit pending, make sure you get that answer filed. And sometimes you can position the case so that you can get a better settlement. If they're being ridiculous and just wanting 90% plus kind of thing, maybe seeking a private arbitration, filing a motion for private arbitration, which I failed to mention. One of our great sponsors here of the weekly live stream, Solo Suit, they have some templates that can help you with filing either an answer or pushing it into arbitration. I put the link in the chat. You can check on that. So, you could do that. And often when you do file a motion to compel private arbitration, and particularly when the court grants it, maybe they'll come back to you and say, that settlement offer looks a little bit better. Trial, very few cases go to trial. I should say, even when you're dealing with like debt collection stuff in the civil world, very few cases go to trial, but that's a possibility as well. But usually I only go to trial if I know that there's a strong chance we're going to prevail on it, that there's got to be some pretty serious deficiencies in the creditor's case. And then you can push it to trial. But usually if there's some pretty big deficiencies, the creditor's attorney knows that as well. And they're not going to go to trial. They're going to get a way to get that done. So great. Oh, and Carla says, I filed an answer using Solo Suit. Good. They also have a tool in there that helps you to file the motion to compel private arbitration. So that's how I would take a look at it. All right. Hercules says, one, I filed a motion for summary disposition a motion for summary disposition was filed against me. And I replied, the plaintiff argues that having my credit card application, date of birth, address, and bill of sale is sufficient to dismiss the case. However, the bill of sale is missing the purchase agreement. Can I use the doctrine of completeness to compel the plaintiff to produce the purchase agreement? Or what would be the best strategy? Yes. Here's what when it comes to this. The doctrine of completeness, it's found in most rules of evidence under Rule 106 is the rule of completeness. And what it says is, look, in fairness, if a party is going to provide you with a document, if they're going to provide you the contract, they can't just provide you every other page. They got to provide you the whole thing so you can take a look at it. But in the debt buying world, with junk debt buyers, they will almost always, in order to prove ownership, they'll provide you with a copy of the bill of sale. And it's usually a one-page document, sometimes two, and it will say like Exhibit A, bill of sale, and it'll have like a little paragraph. And usually it doesn't reference your account, your name, anything like that. And it references that the accounts are attached as an exhibit, or it's an electronic file that was transferred. And it often says that they were part of a much larger document called the forward flow agreement or the master purchase and sale agreement. You can get that document. That's the document. Sometimes the creditors will say, oh, it's not relevant. That's why we didn't provide it. It's not relevant. It's the only reason you could file this lawsuit, because it's the contract that gives you the power and the rights to be able to do it. Now, they always claim that there's some trade secret things in there that need to be protected. I can tell you, in my experience, when I want that document and I've asked the other side to provide it to me and they refuse to, the courts will order them to do it. The courts recognize that it absolutely is relevant. They might be able to redact out the price that they paid for the debt, but the court will do it. And so the way that you're going to get that is through written discovery. You can provide what's called a request for production of documents. It's a written, it's usually Rule 36, I believe, in most jurisdictions under the rules of civil procedure. And then you're going to send that over to them and you're going to ask for that particular document. The way that I do it, so that you don't have them playing games, because sometimes you'll send that over, they'll be like, what are you talking about? And I'm going to be like, I actually attach a copy of their bill of sale. I highlight it, all the arrows pointing. This is what I want. I want this document. Send it over to me. They will always file an objection. They're going to say objection, relevance, trade secrets, all this kind of stuff. Then you can reach out to them and say, look, I think I need a copy of that. If you don't provide it to me, I'm going to file a motion to compel. And if they don't provide it to you, then you file a motion to compel with the court and tell the court, look, I'm requesting this document. Here's proof that I requested it. Here's proof I tried to resolve this informally, and they're just blowing me off. And then make them come in. The judges will typically require them to turn that over. And I can tell you, in my experience, most debt buyers do not want to turn it over. They do not want that document out in the public. They also don't like it because there's disclaimers in there that says basically, look, the seller is saying, look, we don't know if any of this stuff is accurate. We don't know if the dollar amounts are accurate. So, they don't want that. And so often they'll either dismiss or take a really low settlement to get it done. So that's a way to take a look at it. So, all right, let's see here. This person says, do you recommend answering all questions with prove it like Solo Suit recommends? Well, I can tell you, so when a plaintiff, a creditor files a lawsuit, the fact that they're the plaintiff, they have to prove it. The burden of proof rests on their shoulders. As the defendant, you don't have to disprove anything. They have to show by what's called a preponderance of the evidence. That means 51% of their evidence must show that you took out the account, breached the account, the amount that's owed, and if it's a debt buyer, that it was transferred to a debt buyer. They've got to prove all of those things. You don't have to disprove anything, which a lot of defendants fall into this thing of trying to be in a defensive posture of saying, look, we're going to try to force them to disprove. You don't have to do that. You can say, prove it, creditor, let me show that. So I do recommend in that, as far as the way that they answer it, usually the three answers to an allegation in those paragraphs in a complaint or a petition, it's you admit it, you deny it, or at this point you lack sufficient information and therefore you're going to deny it. So that's typically how I take a look at it. Stoic Steve says, how can you explain how to protect an inheritance if filing a Chapter 7 bankruptcy in Arizona? Love your channel, by the way. Thank you, Stoic Steve. Keep up the good work. Okay, so protecting an inheritance in a Chapter 7 bankruptcy. Here's what the rule is under the bankruptcy code. If you file a Chapter 7 bankruptcy and you become entitled to an inheritance within 180 days, roughly 6 months from the day your bankruptcy case is filed, if you become entitled to an inheritance, the bankruptcy trustee, one, you have to notify the court and the bankruptcy trustee, and two, they can go in and go after it. So really there's no way around if you become, because, and I should say this, when you become entitled to it is not when the money is actually distributed. It's when whoever is leaving you the money passes away. If that happens within the 6 months, because that's when you become entitled to it. That's the event that triggers you becoming, an heir under, whether it's a will or trust or whatever it is. So also depending on the kind of asset that it is, that you may be able to exempt out some of it, if it's life insurance, things like that. But it's kind of a hard and fast rule. If you receive the inheritance prior to filing, then you're going to need to meet with an attorney. You're in Arizona, feel free to click on the link, the scheduling link I put in there. I'm happy to go over with you that in more specifics, but we would have to see exactly what the inheritance was you received before filing, how much it is, and if it can be protected. It may that it can't be that it can't be. But the tough thing is if you receive them after. If you receive it afterwards, it's a tough thing if it's within that 180 days. All right. Karen says, hey, John, good night. What is the difference between a debt buyer and a debt collector? Good question. And you know what? Sometimes I love questions like this, because sometimes, if you're working in this area all day long, you just kind of get accustomed to some of the terms, and it's good to distinguish it. So, and I'm going to throw in a third one there, and that's the attorney who represents these entities. So a debt collector, when the debt goes into collections. So let's say that someone goes into default on a credit card, they haven't made it in a couple months. The company, the credit card company, is going to do internal collections themselves with phone calls. They may hire a debt collector. The debt collector has no ownership interest in the underlying debt. They're just hired gun. They're hiring them to call and annoy you and get you to pay. That's a debt collector. The debt collector has not purchased the debt. They haven't been assigned the debt. They're just hired by American Express to do the phone calls and be annoying and try to get the thing in. That's a debt collector. They'll do that for 6 months. At the end of 6 months, the creditor is required to charge off the account. The charge off does not mean that they can't try to continue to collect on it. They can. They do. It's 100%. Everybody who hates me on the YouTube for saying this, I'm sorry. It's true. The courts are full of thousands and thousands and thousands of lawsuits of charged off debts. That's all they're full of, is charged off debts. So now the debt buyer, though, is once the debt is charged off, many credit card companies will package up these charged off accounts into portfolios, and they will sell them on the open market. They'll sell them, just saying, hey, we're going to sell these accounts, the right to the payment on these accounts, and we're going to do it at a discount. So if it's Synchrony Bank, they reach out and they say, hey, who wants to buy these? And LVNB or Midland Funding or Portfolio Recovery comes in and says, look, we'll buy that portfolio of accounts for the right to sue on them. We'll pay you 3 cents on the dollar for them. And then we have the right to sue. The original creditor is out of the picture at that point, and then they can sue. And so they didn't pay hardly. So like Midland Funding, FTC says that on average they pay 4 cents on the dollar for their accounts. Okay. And so they pay 4 cents on the dollar, but then they go out, if they settle it for 50 cents on the dollar or 60 cents, or they sue you and garnish you and get 100 cents on the dollar, then they're in a situation you can see the profit. That's how they make the money. So the debt buyer is saying, we actually own this account now. We bought it from the original creditor, whereas the debt collector is much different. Now, the last one I'll go over is the attorney, because a lot of times people will get sued, and I will say, hey, who's the plaintiff, or who's the party suing you? And they'll say, oh, it's Gerstel Law Firm or whoever, one of these big debt collection law firms. The law firms typically don't have any ownership interest in the actual account. It's not something where they're part owner of the account. They are just a law firm, just like I'm a law firm. They've been hired by the debt buyer to file this lawsuit, but they typically don't have any type of ownership in it. So, all right, let's see here. Paul says, do you have any similar resources for Canadians? You know what? I practice in Arizona, and I know a lot of the laws in the states are very similar. I don't know, my dad's Canadian. I know that. My dad from Claresholm, Alberta. I don't know, Paul, if you're from anywhere near there. So I have a lot of family in Canada, but I don't have any. And the judicial system up there is different enough that I wouldn't even venture to say exactly how to handle it. So that's something I should look into, though. But I don't have that off the top of my head here. So, all right, let's see here. What a Beast says, what happens after I file my answer? How long does the plaintiff usually take to respond? Good question. So in most jurisdictions, when an answer is filed to the lawsuit, the plaintiff doesn't respond to your answer. The way you got to look at the complaint or the petition and the answer is it's the creditor saying, hey, here's my list of allegations in my complaint. What say you? What a Beast. And What a Beast says, well, here's my answer. I either admit or deny what it is that you're alleging. So then the court can see, okay, we have a dispute here. Creditor says this. Consumer says, I agree or disagree. So there's a dispute there that they have to deal with. The next step is usually the exchanging of disclosure statements. It's usually within somewhere between 20 to 40 days, depending on the state, depending on the court. And what the disclosure statement is, these are documents that are typically not filed with the court, but where they have to disclose any exhibits, witnesses, legal theories. Basically, both sides show their cards, usually about a month after the answer is filed. Then the case goes into a discovery period where documents can be requested, like I was talking about before. Depositions can be taken if either party wants to do that. And then it will usually head towards a trial type setting. That process in some jurisdictions can be very short, 90 days. I've seen in Arizona, even in the justice court that deals with cases under 10,000, it'll take you almost a year to get to trial. So it takes a while, but that's really what you can expect next. All right, let's see here. I'll follow up Hercules again. My hearing on the plaintiff's summary motion is this Monday, and our actual trial is in September. Do I still have time to submit a request for production, or is it too late? It's a good question. You're going to need to look at the rules of civil procedure for your particular court. There usually is, I can tell you most courts, there's a discovery cutoff. There's a deadline. If the court hasn't issued one, then sometimes there's a default deadline that says, look, it's 90 days or 60 days before trial. So you may want to look. It may be too late because usually there has to be enough time. Usually they get 30 days, 40 days or whatever to respond to it. And if there's not enough time for them to respond to it, then the court's not going to let you do it. But look at your rules specifically on that. All right, here. Doodle Art TV says, is there a way to file a claim of improper service from a debt collector? I filed a motion to compel, and the judge said to file a responsive pleading and an improper service claim. Can the motion to quash be used? So if there's been improper service, it's kind of funny. I had a lot of these conversations today at work here in my practice in Arizona. But if service has not been done properly, where they initially they file their complaint and then they send a process server or a constable or a sheriff over, whoever, to serve you with a copy of the complaint and the summons. That's giving you notice of what it is and starts the clock ticking for you to file your answer. If they haven't served you correctly and they got a judgment, that may be the basis to be able to get the judgment set aside. However, if they didn't serve you correctly and then you still became aware of the lawsuit and you came in and you filed a motion, or you basically let the court know, hey, I'm here. At least in Arizona, if you've made a general appearance, the court's essentially going to say, look, you waived service, because the whole point of service was to give you notice of this lawsuit. You clearly have notice because you're here in the court filing documents or whatever. So, if it's something where you feel like the service is improper, sometimes there can be a Fair Debt Collection Practices Act claim, an FDCPA claim, if there's some kind of problem with there. But I don't know if you'll have a claim there specifically, particularly because it sounds like you've already made what do you call it? You've made an appearance in the case. All right. None of your business says, have a friend in AZ failed to answer a request for admission, and she had filed a motion to compel, which was pending. What could she do? So good question. So this is part of that written discovery process. Again, there are certain debt collection law firms, Johnson Mark, a firm that's in both Arizona and Utah. They often will file requests for admissions. Now, requests for admissions are the written discovery. It's a written document, and it's just a list of some questions, and the only option to answer it is admit or deny. And so they'll throw over questions that seem kind of dumb, like admit that all of our documents are admissible in court, and you have to admit or deny. Admit that you owe us $9,652, admit or deny. And the reason why they do that is because under most rules, if you do not respond timely to the request for admissions, the court will deem them admitted. And so what you'll often see is they'll send over the request for admissions. People don't know how to respond to them, and they don't respond to them. Then they will attach that as an exhibit to a motion for summary judgment, saying, look, judge, they already admitted everything, just enter judgment against them. If they have been deemed admitted, if they failed to answer to them, you could file a motion to set aside the responses. And as long as a trial date hasn't been set, or even if one has and it's a long ways away, my experience is most courts will grant that. They'll set it aside and say, look, creditors just trying to play a game of gotcha here. So it's something where they should, we'll set these aside and allow you to respond to them, and they'll give you a deadline to do it. But you have to ask for it. The court's not just going to do it automatically. And if you don't, you're likely going to be facing with the motion for summary judgment here pretty quick. So let's see here. Maybe I was answering the wrong question. She has filed a request for reconsideration on motion to compel arbitration. Yes. So the motion to compel private arbitration, it's an approach, like I say, where you're trying to get the case out of arbitration, push it back into, or out of court and push it into private arbitration. I don't understand why judges deny this. It's the creditor's agreement. This isn't the consumer just making something up. This is their contract. Their contract gives you the option, assuming it does. You've got to have that. If it doesn't have that, then you're not going to win. So a motion to reconsider, if a judge denies a motion to compel, as long as you're meeting the terms of it, you've just really got to hammer that home. Have a copy of that attached as an exhibit, highlight it, and say, look, we want to be in there to be able to get this done. So motion to reconsider in most jurisdictions is a way to get a second bite at the apple. In essence, the court may deny it, but it's something where if you feel strongly about it, you can go ahead and pursue it. So, all right, I think that will do it for today. Appreciate, again, everybody checking in. And if you're needing some help, go check out our friends over at Solo Suit. It's a great way to, they have some great tools there to help you out. I'll put it in the chat there. It's also a great way to support the channel and provide some great information as far as debt settlement, responding to lawsuits, and even motions to compel private arbitration. Go check that out. If you're in the state of Arizona, you need help, my link's in there as well. My information's below in the notes. Feel free to reach out. I'd be happy to talk to you. And with that,